If your partner or spouse is overseas and you want to bring them to Australia to join you, this video is for you. The offshore partner visa process requires strong supporting evidence about your relationship and clear documentation that meets the department's requirements. In the next few minutes, I'll explain how this process works, what you need to know before you proceed, and what to watch out for along the way. The Subclass 309 visa is the offshore provisional partner visa. It is for applicants in a genuine relationship with an Australian citizen or permanent resident who are outside Australia at the time of application. Applications are lodged with the Department of Home Affairs. If the Subclass 309 visa is granted, the applicant can travel to Australia and remain in Australia under that visa. To qualify, you and your partner need to be in a genuine and ongoing relationship, either married or in a de facto relationship. The department assesses relationships across 4 areas: financial arrangements, living situation, social aspects, and commitments to each other. For offshore couples, this does not mean joint bank accounts or a shared lease. You are living in different countries. What the department looks for is evidence the relationship is real and ongoing. Travel records, communication history, financial support across borders, photos, and statutory declarations from people who know you as a couple. The evidence looks different for offshore applications compared to onshore partner visas. What matters is that it clearly addresses each of the 4 required pillars. If the application contains gaps or inconsistencies, it can lead to requests for further information that set processing back by months. Weak or poorly organised evidence can raise doubts about whether the relationship is genuine, and once those doubts are raised, they are difficult to overcome. There are also sponsorship issues that catch people out. Not everyone is eligible to sponsor a partner visa, and the department assesses the sponsor separately. If there are previous sponsorships, character concerns, or other factors that haven't been properly considered before lodgement, it can create serious complications. The most common issues we see with offshore partner visa applications fall into 2 categories: problems with the evidence and problems with the sponsorship. With evidence, the mistake is usually not a lack of documents, it is the wrong kind of documents. Generic couple photos and vague statutory declarations do not meet the legal criteria. The department assesses relationship evidence across 4 specific areas, and if the evidence does not clearly address each one, that is where refusals happen. With sponsorship, the most common issue is not checking eligibility before lodging. There are limits on how many people a sponsor can bring, time restrictions between sponsorships, and character requirements that must be met. Discovering a problem after lodgement is far worse than identifying it before. If you are planning to sponsor your partner for an offshore visa, getting proper advice early means you go into the application with a clear picture of your eligibility, your evidence, and what the department will be looking for. A well-prepared application is the best thing you can do to reduce processing time and avoid a request for further information, or a refusal on grounds that could have been avoided from the start. Before you engage any migration lawyer, there are a few things you should watch out for. Some firms will pressure you to sign on the spot. They'll offer discounts, create urgency where there is none, or find other reasons why you should commit before you've had time to think. These are sales tactics. Any firm that needs to rush you into a decision is more interested in your fee than your visa application. At My Migration Lawyers, we do the opposite. We give you a 2-day cooling off period and send you a complete information pack of 7 documents before you make any decision, covering fees, refund and complaints policy, service commitments, and your rights as a client. You read everything at your own pace before you commit a single dollar. Once you engage us, you get regular updates at every stage. At MML, your rights come first. Book a consultation with one of our migration lawyers. We'll assess your situation, give you realistic advice, and tell you exactly where you stand. Let us show you the MML difference.